Oh, there. Hey, everybody. Welcome to episode 229 of the Immigration Lawyers Podcast. We had some loading delays, but it came in. Thank you for joining us today. We're doing one of our monthly regular episodes with Kevin A. Gregg about federal litigation, federal updates, BI, all that stuff that I don't really handle. So we have the boss here who does. And coming back from touring the U.S. on his immigration tour and helping immigrants all across the country, will be joining us in a second. I want to let everyone know that the issue 4 of Immigration Lawyers Toolbox magazine is out, a wonderful issue. They get better each time, as you imagine. So chock full of content from all over the place. And we have a wonderful cover story from Spojmi Nasiri, a wonderful colleague who has Afghan heritage, who talks about the crisis there. And as soon as one crisis comes up, another one pops up. As soon as one happens, another one. So probably next issue is going to be focused on Ukraine and the disaster that's happening there. But before we go into it, I want to talk about drwise.com. DrWise, the immigration form software, has been a supporter of both the podcast and the magazine. Much appreciated. Their form software helps so many people, but it's not just form software. It's practice management. They even do text messages through Office. So if you're doing marketing and stuff, they help out with that. It's a whole slew of features that they have that I can't even go into here. We do regular quarterly interviews with one of the founders. You can learn about the most updated stuff there, or just contact them. You get 10% off their annual plan by using the code for the show. Immigration. Just go to drwise.com/immigration-lawyers-podcast and use the code Immigration Lawyers Podcast, and you'll have a good time helping them out. If you want to join the free directory, not directory, but library of information I have for the Immigration Lawyers Toolbox, it used to be a paid subscription service. I made it free. If you're a practicing immigration lawyer, email me at info@immigrationlawyerstoolbox.com. That's the business email for that one. And let me know you want to join, and we'll get you in on that. We have tons of information, training, updates, all this kind of stuff we put there. So I think you're going to like it a lot. I always have a lot of things I'm supposed to talk about at the beginning, but I usually forget all of them. Main thing is the magazine. Go check it out, immigrationlawyerstoolbox.com/magazine, and read it, download it. And it's a game changer. You learn so much about everything. I do myself in reading it. I could say that. And I've been doing it as a professor 12 plus years and all this kind of stuff. It really is new stuff you learn every time. With that said, I want to bring our esteemed colleague, host of Immigration Review podcast, one of the top rated, if not, 1, 2, or 3 top immigration podcasts in America, Kevin A. Gregg. Thank you for coming on.
Thanks, John. It might be international too. You as well. I mean, I don't know if you post to Buzzsprout, but I like looking where all the locations for the downloads. I've got Uzbekistan. I mean, you name the country, there's like one. And I don't want to think. I like to think that it's people listening and not some weird, I don't even know how the tech goes with the internet that it's going through a country. So it's
that's true. A VPN or something like that. Yeah, I hear you.
That's not what it is.
Yeah, I haven't looked at that. I use Lipsim, Liberated Syndicate. They have a world map. I haven't even looked at it in a while. But yeah, it's interesting seeing, just even on your Google Analytics for your website, if you use that, just seeing like all the places where they're looking every month on your website. And really what we do is always international because it's the nature of it. So it's really neat. But you have been, literally traveling across America, doing cases and stuff. So, you get tired. I'm good. You told me earlier that you had one of those 15 flights for this year so far. That's it requires stamina to deal with that.
Yeah, no, it's a good thing though. I find it kind of fun. I like sitting at my desk and writing stuff, but it's also fun, traveling around and doing the cases. And I don't have to,
when I first started traveling for flights to go to USCIS interviews and stuff like that, and you do obviously court cases too, I always felt like a big shot first. Like I finally grew up. I have my suitcase. I'm on an airplane, business traveler. But then after a couple times doing it, I'm like, this is kind of weird on me. I'm getting tired. I did get a global entry, so I don't deal with TSA. If you don't have that, you have that, assuming, right?
Necessary. I went to a hearing with John Pratt once in Orlando, and he had TSA pre-check and I didn't. He was in line. I was in line for enough time that he got through, ate dinner, and was done. By the time that I got through, I said that's it, never again.
Yeah, just I'm sure you got that. Everyone's listening, get it. It's a game changer. Even if you just need to go one flight a year, to ever have to go through TSA again is horrible. Sometimes when you buy the ticket, they randomly will force you still to do TSA. That's happened to me, but overall, it's so nice just strolling in there like travel used to be like pre 9/11 almost.
So, Immigration Lawyers Toolbox and Immigration Review, get TSA pre-check.
We should pay them for this advertising, but it's a lifesaver. So we got a lot of cool cases we're going to talk about today. So let's jump into it. Which you got first?
Well, I think this is the first time that you've made a pre-meeting request. You want to talk about the Adeyanju v. Garland decision out of the First Circuit that I talked about on the podcast that dropped yesterday, because it was published on February 24th, and I've said Adeyanju enough times now that I think I'm saying it right, Mr. Adeyanju.
So smoothly. I'm like, you're so confident in this. My eyes just glaze over. I'm like, it's First Circuit case. That's all I know.
Yeah, he's from Nigeria. Sometimes and Chris Rickard, who stepped in to help host the show when I went on vacation 2 weeks ago. Sometimes I'll often try to find the oral argument of the case, so I say these individuals' names right, especially when they're difficult. But Adeyanju, I think I got. I didn't even look that one up. I'm pretty proud of it, so hopefully I'm saying it right. But the case was nuts. I mean, as I said on the podcast, it was like 33 footnotes. It's like 60 pages. It took me an entire flight from Seattle to San Diego to review, pretty much, and it's just wild stuff going on. But it's about discretionary fact finding and, eyes glazing over again. And there were some interesting facts in it and removal proceedings, but you wanted to talk about the fact that there was an I-751 and how that gets adjudicated in court. And quite frankly, I have some questions about it and reviewing it. And I'm not sure that what happened in the case is appropriate, but also, I got to check myself because it went all the way to the First Circuit. And maybe it was, because as to the I-751, in essence, Mr. Adeyanju got married to a U.S. citizen after coming to the United States through a tourist visa, so he was admitted, and he got a conditional lawful permanent residency, and they filed a joint petition to remove that condition and the joint I-751, but the wife, there were marital problems. The wife at the interview apparently said this is a fake marriage, although she said she didn't say that later. And those USCIS interviews are not always 100% accurate. It's not even a transcript. But then they did divorce, and he marries the woman who probably led to the marital issues, the mother of his child, who is also a U.S. citizen. So now he's in removal.
With during the time, essentially. So yeah, the fact patterns, it's all over the place, and it's kind of messed up the situation. But yeah.
but it's important to the I-751 because with the condition not removed, right, you get placed in removal proceedings where an immigration judge is doing de novo review of whether the condition to the LPR status should be removed. Fine, and all removal practitioners remember it's not an appeal of the USCIS decision; it is de novo review. The USCIS decision is really just evidence. It's not even important, quite frankly. Yeah. Maybe there's grounds to try to not get it admitted, but that would probably fail. But it's de novo review by the immigration judge to determine whether or not the condition should be removed. And so there's a jointly filed I-751 petition pending in immigration court. But during those proceedings, his second wife, it looks like, files an I-130, and he tries to adjust through her. And that's what actually makes its way up to the First Circuit. But I'm not quite sure how that can happen. Because, so you've got a guy, Mr. Adeyanju, who is a conditional lawful permanent resident. That condition hasn't been removed. Can he file a new adjustment of status application in immigration court unconnected to that?
There was a memo that came out a year ago. It might have been based on a BI or something like that. But and I haven't dealt with it, but it said that if you get your I-751 denied, you could then pick up and do a new adjustment case with a new marriage.
You can do it certainly before USCIS, but in immigration court, when you're placed in de novo I-751 review, I mean, you must be able to, right? Because it made its way all the way up to the First Circuit. It's just something, every time there's an I-751 conditional case, I got to go back to the statute and the regs and the case law and really wrap my head around what the IJ has authority to do.
Yeah, I think they even refiled an I-7, because normally you just refile an I-751 and that would force USCIS jurisdiction to do it over again. So that's the strategy I would have used. And then I would have filed the I-130, but they're in court, so it's going to be that special higher burden. Sorry, go ahead.
But yeah, no, just so much going on. But so there is.
Just a pause. That's why everyone listening should read this case, because if you're a USCIS practitioner, it talks about what happens when someone's proved, what route they went under, what facts USCIS took into consideration when they're reviewing it. It's kind of a good primer to see the worst case scenario, what happens with this stuff. So that's what I thought was really interesting. But go ahead.
But so he would have no basis to file a new I-751 with USCIS through the second wife, right? They would have to file an adjustment. There's no 751 through the second wife because there is no adjustment pending. But he can't file a new adjustment with USCIS with the second wife because the immigration judge has jurisdiction. Mr. Adeyanju does eventually.
You can always refile an I-751 if it's denied to keep it at a court, can't you? Like, even if it's denied, then you file a waiver version of it.
Right, and that's what Mr. Adeyanju eventually does. He files a waiver of the joint filing requirement, but it still is the same issue. Was this a valid marriage? So he does do that. He files a waiver, but that's still based on the first marriage. And that gets filed with USCIS unless and until it's denied. But simultaneously, he has filed a new adjustment of status application through the second wife with the immigration judge. And really, that's what went up to the First Circuit. And so he's got two wife petitions essentially going on at the same time. And
one notice, they NTA'd him as soon as the first denial came through. The day after it was denied, they NTA'd him. They didn't even give like some time or something. So be prepared for that kind of stuff. Clients going down that road.
Yeah. And so with that second I-751, there's a whole, most of the case is about whether or not the immigration judge improperly denied and the BIA improperly denied the adjustment as a matter of discretion. Because actually, the immigration judge ends up granting the adjustment through the second wife, and then the BIA, which is, I love my clients. I don't know Mr. Adeyanju. There's a rough fact pattern there, and that immigration judge.
You haven't read it. The IJ reads the fact pattern and still approves the adjustment. My head was going like, I thought IJs were like, I was like, who's this IJ? Like, that's like incredible that they still approved the case.
Hey,
together and say, what, you can't deport the dad or something like that. But that was extraordinary that the judge was like that lenient, frankly, on these facts.
There was, I'm not saying Mr. Adeyanju did it. I have no idea. But at the time adjustment was granted, there were pending kidnapping and rape charges. Now, the IJ knows much better than me and apparently knew better than the board, because that is the reason that the First Circuit ends up remanding it back to the board, because the board, according to the First Circuit, went out of bounds in overturning the immigration judge on some of the fact finding. But the First Circuit also remands, and this is the I-751 stuff, to determine whether or not the First Circuit should send it, the BIA should send it back to the immigration judge for continuances until USCIS decides that second I-751. And that's matter of Stowers and matter of Mendez, which essentially say if there is an I-751 pending before USCIS and the immigration judge has jurisdiction over the case, the immigration judge is supposed to keep granting continuances, and I'm paraphrasing, until USCIS decides that I-751, at which point it'll either be granted or the immigration judge will then have authority to do a de novo review of that 751. And that is the incredibly complicated tangential issue on Adeyanju v. Garland.
It's interesting because in it, the judge says, I'm going to grant the adjustment of status unless you want to go to I-751. It seems like, client's counsel said, no, we're good with that. We'll just keep we'll accept the adjustment. It was like a one-liner they threw in there. So it's kind of like it was weird.
Three things. First of all, I don't think that the immigration judge could have granted the second I-751 because I think it's jurisdictional that USCIS has to decide it first. So that's out. The immigration, and whether the IJ shouldn't, the IJ shouldn't be granting adjustment of status if the IJ also agrees that marriage fraud has occurred previously. And that part
makes sense too. Yeah, big time, yeah.
And so by granting adjustment, the IJ is essentially saying, I don't believe marriage fraud happened in the first. But if that's the case, then just remove the condition.
Yeah, exactly.
Because the jointly filed I-751, as I understand it, is before the IJ. Maybe not, because they divorced in the interim. Maybe that's the issue. Maybe the First Circuit doesn't get into it. Maybe an immigration judge cannot de novo grant a jointly filed I-751 if the couple is no longer married. Maybe that's the problem.
Maybe. Now, I was going through this issue I I-75 once because we got one approved where the person was midway divorced and we notified USCIS that they're divorced, so we're doing a waiver. And
Right.
then like they just approved it as a joint, and so we're trying to like see like if it's correct or not and stuff. But reading the memos, it kind of says USCIS has the authority, even if they know they're divorced, because their divorce certificate was not finalized. So we notified them divorce in process, and they still approved it, even though they're kind of not supposed to. They're supposed to. They had this whole thing.
That
So on its own said they kind of pull this off if they want to. So does that mean IJ has to be stuck by statute though? They cannot USCIS interpretation.
but so I think that's the explanation to me though. I mean, they're not divorced at the time USCIS adjudicates it, so that issue is not there. But by the time they get before the immigration judge, they fully divorce. So I mean, that's not the same thing as that must be it. Even though they were placed for de novo review, maybe the immigration judge couldn't remove the condition even if he or she wanted to, which requires the second adjustment filing and a potential waiver filing with USCIS first if you want to go the 751 route. But again, USCIS must then decide that waiver filing in the first instance, matter of Stowers continuances.
Probably the whole I-75, always people call me when they have issues with divorce midway or relationship going bad when I-75 is pending. I'm like, this is the worst place to be in immigration with USCIS practice because the way they design I-75, especially with the delays that it takes, it's like a nightmare for people that fall in that situation trying to fix it up and do all that kind of stuff. But it's interesting, yeah. USCIS, like if an I-751 waiver, I-751 not even waiver, but is denied, does that automatically mean fraud, or does it just means they didn't meet the burden?
Well,
it kind of means the same thing essentially. We don't believe issue is real,
yeah.
but I mean, when you make a fraud thing, you kind of have to back it up, and it goes into like
it's not a 204C I-130 finding, and it's probably I think it's a burden issue. In Mr. Adeyanju's case, I think USCIS flat out said we think there's marriage fraud. But either way, the framework is de novo review before an immigration judge. So you get your second shot before the immigration judge to meet the burden.
And would that, if the immigration judge thought it wasn't fraud, that would undo a USCIS finding, so they go back and do a new I-130?
USCIS's findings didn't mean nothing. Doesn't mean anything. The immigration judge orders the condition removed, and the person is a full-fledged green card holder. That's what happens. USCIS produces the green card as ordered by the immigration judge. I had one done last year in Miami.
In this case, I think they filed an I-130. Did USCIS adjudicate that, approve the I-130?
That is not discussed, but that must have happened because
it's so crazy. Yeah, like I read this, like, oh, we got to talk about this one first. There's just so much stuff.
A 60-page decision, and there was not enough discussed that we have to connect the dots.
This stuff's so complicated, and federal judges don't deal with immigration so much. I bet every time they see an immigration case, like, oh shit, like we got to read this, like, learn immigration law now.
I'm not knocking the first; they did a great job, but I mean, it's complicated.
It's annoying because if you're dealing with like corporate or criminal law case, which you're usually dealing with, and all of a sudden immigration comes, which is like completely different than you deal with. Not to knock it, it's just like it must be annoying because it's so out of left field, this kind of stuff.
Well, they had some fun with it. It has nothing to do with the I-751, but as I said on the podcast, they said that the clear error standard of review in the First Circuit, and this is a quote, is akin to a 5-week-old unrefrigerated dead fish. That's a quote from the First Circuit about standards of review. So they had some fun with it.
Yeah. How long have you been talking about this subject? Let me look at the count. It was like 20 minutes.
All right. We'll get on to the next. I've got the other two are short anyway. Just
definitely read that case. It's worth reading if you're USCIS, anybody, but especially if you practice USCIS. It gives you a different perspective, or just fills you in on what the hell's going on with this kind of stuff. But go ahead, Kevin.
Or episode 96 of the Immigration Review podcast. I think it's case 3 discussed. Now, the other two are, I'm trying to focus on the good that comes out in the month before I come on your show, because who wants to talk about all the bad? So the good is, the common issue I keep talking about on your show and everywhere. This one is Singh v. Garland out of the 9th Circuit on February 4th, 2022. And this is, in my podcast, I actually referenced you because you and I have been talking about this issue in the last video we did in February. And this is the Niz Chavez motion to reopen in absentia motions, orders in absentia orders of removal where there is a deficient notice to appear. And the Ninth Circuit in Singh, as I read it, essentially says you gotta reopen them. If you have an order of removal, if an in absentia order of removal comes your way in the Ninth Circuit and the NTA doesn't have the date, time, and location of the first removal hearing, I read Singh as saying that case needs to get reopened. Doesn't matter if you can't overcome the presumption of delivery, doesn't mean anything. The Ninth Circuit is saying they need to be reopened. And that is like, I don't know, 50% of all in absentia removal orders are probably issued in the Ninth Circuit since 1997. Not only that, the Fifth Circuit, as I keep saying, issued a similar decision in, and let me just get the case, and Rodriguez v. Garland discussed, like on episode 84, or discussed a long time ago, the Fifth Circuit was first. So we got between the Fifth Circuit and the Ninth Circuit, and the Fifth Circuit's a bit more nuanced because then another decision comes out 2 weeks later. But between the Fifth and the Ninth, you have incredibly strong cases for why in absentia removal orders based on deficient NTAs must be reopened. And between the Fifth and the Ninth, that's like 90% of in absentia orders of removal, because that's where everybody's coming in, right? They're coming in through the Arizona, California, or Texas borders, and that's where most of the in absentia removal orders probably happen because people end up not showing up.
From what I recall, there was another circuit that went the opposite way, right?
No other circuit has went the opposite way. The Board of Immigration Appeals, however, in matter of La Para, is trying to get ahead of it and, disagrees. But the Fifth, the Ninth, and the Board are all basing their rationale on the statutory text. And they all think it's clear, which is funny. Because, if they all think it's clear, then obviously it's not. But more importantly, if it's based on the statutory text, it doesn't matter what the board says. Because the circuits don't defer to the board when it comes to textual analysis on the plain statutory text. They only defer to the board if the issue is ambiguous. So yes.
Something or the other deference?
Chevron deference and Brand X. Yeah. So what that means is, yes, matter of La Para governs in all the circuits right now, except the Fifth and the Ninth. But it means that matter of La Para doesn't mean anything in the Fifth and the Ninth. And that's where most of these cases are. And it means that you should be preserving the argument based on Rodriguez and Singh in all the circuits that haven't spoken yet. Yeah. Even though, yes, matter of La Para likely governs in those circuits until, and it's going to happen. Those circuits are going to issue a decision eventually. Every circuit has an in absentia motion, and it's going to probably go to the Supreme Court. We're going to have the third incarnation of this deficient NTA thing, because a circuit split's going to happen. There's already a split if you consider the board a circuit, which it of course is not. But this is the nerdiest stuff, but the implications are substantive and serious and crazy.
Huge implications. Wow. Well, it's ongoing. I'm sure we're going to have a bunch of more circuit stuff. We're going to think all year probably.
We're talking about this for years.
Yeah.
and the Supreme Court knew it, and that's why I think Justice Alito, in dissent in Pereira, I think it's pretty much what he said as the sole dissenter. He's like, "Yo, this is a big deal, guys," and they're like, like, is it?
Yeah. Good stuff.
Not to side with Justice Alito. It's not something that I often find my belief system of law doing. Nor am I doing so here, but I must give him a shout out that Justice Alito did say this is probably going to happen.
Yeah, very interesting stuff. I mean, the consequences are so humongous, and like the practitioners really got to be on top of this one, because this is like, especially people who do removal, this is so like an incredible thing.
Yeah, it's crazy.
Cool. So
last one, I just like the case, and maybe I might have even talked about it last month on your show. I can't even remember, but it's Osmani v. Garland out of the Seventh Circuit, and I just like it because I love burdens. And I'm not going to get into everything, but essentially Mr. Osmani was applying for adjustment of status, the refugee adjustment of status based on Section 209, which has been coming up a lot in the circuits and at the board recently. I don't know what it is. There can't be that many Section 209 refugee adjustments, but like it seems to be what all the circuits are publishing on in the last 2 months, and the board has published twice on it at least. But anyway, Mr. Osmani, the immigration judge denied a 209 adjustment as a matter of discretion. No, I'm sorry. The immigration judge granted 209 adjustment as a matter of discretion, and then the DHS appealed. And the board then overturned the IJ. And then, unfortunately, they deported Mr. Osmani, but now they got to bring him back because the Seventh Circuit remanded the board's overturning. And this is what I like about it. It's because ICE, before the IJ, didn't take a position on his waiver. Didn't say, we don't believe he warrants a waiver as a matter of discretion. ICE didn't say that Mr. Osmani didn't warrant adjustment as a matter of discretion. I think they just said, we've made our position, judge, you decide. And what the Seventh Circuit said, and I'm going to quote it, is that the BIA, quote, will not consider an argument or claim that could have been but was not advanced before the immigration judge. Even though Mr. Osmani, as all non-citizens trying to get relief, have the ultimate burden, if ICE doesn't take a specific position before the IJ, essentially if ICE doesn't say, judge, we don't think he warrants it for this reason, then it would seem, based on Osmani, ICE can't change their mind on appeal. ICE really can't even appeal, other than to say that the immigration judge made a mistake in the fact-finding or something, but the ICE can't now say all these reasons that the non-citizen doesn't warrant relief on appeal. And I mean, it's essentially holding ICE to the same burden that is held with non-citizens. Multiple times a year, the board is coming out with decisions published that say non-citizen can't advance arguments on appeal that weren't advanced before the immigration judge, often in the particular social group context where, they come out with 15 new PSGs on appeal and they only put 5 forward before the immigration judge. So I'm always going to want to talk about a decision that holds ICE to the same burden as non-citizens counsel.
Which circuit was this?
This is the 7th, and it's Osmani v. Garland.
Okay, very interesting. That is important. The equality and how they do this and stuff, these double standards is always good news. Well, awesome. Well, these are very interesting cases. That was lively. I'm tired from a long day, but I actually got excited talking about this stuff. This is the best episode that we've done. I was really interested in all the cases.
I kind of got jacked up.
Yeah. If you're a nerd for this stuff, it's fascinating. So we'll have you back on again next month. Thanks so much for coming on again. Really good to go. Anything else you want to leave us with? Obviously, Immigration Review podcast. Check it out. A lot of practitioners, people will contact me and say, they listen to both of ours and they really get a lot out of listening to you. So definitely check it out. It's a good one.
Thanks, John. I got nothing else. And congratulations on all your continued success with all the crazy things you're doing.
I appreciate it, bro. Thank you so much. All right, everyone. Have a good one. Check out the magazine, Immigration Lawyers Toolbox Magazine.com. No, it's immigrationlawstoolbox.com/magazine. That's the URL. And hey, we're waiting for the Kurzban, Tizeli, and Pratt. Did I say it right?
That's right.
A contribution to the magazine as well. So what am I waiting for?
All you got to do is ask. All you have to do is ask. I've said you haven't asked.
Yeah, let us know some topics. We're always looking for, especially removal kind of topics, or more the stuff, the business employment side I usually pull together because I know a lot of more people in that world. But let me know a topic you want to write on, or associate or a partner wants to write on. We'll get it in. Much appreciated. All right, everybody. See you next time.
Bye, Jen.